Hello, and welcome to Understanding Mediation, presented by the Texas Advocacy Project. This video is sponsored by the Texas Bar Foundation. Thank you for your support. Mediation is a way to solve legal problems without going to court. A trained mediator helps all parties communicate to try and find a resolution or compromise. If everyone agrees, the mediator writes the agreement down and has all parties sign it so the court will honor it. If you have a mediation coming up or are thinking about agreeing to schedule a mediation, it is important to know all that you can about what mediation is, what the process looks like, and how to prepare for it. The information provided in this presentation does not and is not intended to constitute legal advice. Instead, all information, content, and materials available on this site are for general information purposes only. Viewers should contact an attorney to obtain advice with any particular legal matter. Mediation is a meeting where parties talk about their case with the help of a neutral, trained mediator who listens carefully to all sides and makes suggestions to help all parties reach an agreement or compromise. They do not decide your case. They are only there to help you communicate effectively with the other party or parties. In Texas, most civil cases can be mediated, and some cases are required to go to mediation before continuing. The court will encourage mediation if they think it will help resolve the case. The process can take anywhere from a few hours to a half or whole day. A mediator is a professional who has been trained in alternative dispute resolution. This means they have taken multiple classes to learn methods of resolving cases without having to go to court. They make sure everyone is respectful, listens carefully, and works together to try to resolve their case or compromise. A mediator is not a judge and cannot decide your case. A mediator is probably a lawyer, but they don't have to be in Texas as long as they have the required training. The court may choose a mediator for you, or it may allow the parties involved to agree on one. A mediator can discuss possible agreements or compromises that they think will help settle your case. They can tell you what they believe is fair or not, and can give you advice based on what each party tells them it would like to get out of the mediation. A mediator can also discuss the facts and merits of the case in relation to the compromise or agreement that is being worked on. A mediator can never take sides. They are prohibited from doing so. Think of them like referees in a game. They cannot pick who wins. Unless you agree to it, a mediator cannot tell the other party or parties what you have talked about with them, or how you were feeling about what was talked about. A mediator cannot force you to make a decision or agreement. Their job is to help you have a discussion with the other party or parties to come to a compromise or settlement. An agreement made in mediation can only be enforced by the court if both parties agree to it and sign it. If the court has not already ordered mediation in your case and you want to mediate, you and your attorney should take these steps. 1. File a motion for mediation and a proposed order on the motion for referral for mediation with the district clerk's office in the county where your case is in. In the proposed motion, you can suggest a mediator that you and the other parties have agreed on, but you don't have to. Send a copy of the motion and order to the other party or attorney. The court will then appoint a mediator to contact everyone to set up a meeting. If you do not have a lawyer, talk to someone you trust about what you think you want to gain from the mediation and what you are willing to compromise. If you have a lawyer, you can speak to them to help you set realistic goals and possible compromises. No matter who you talk to, it's a good idea to list topics you want to discuss. This can help you stay organized. Some issues you might want to put in your list are children, so decisions about care, living arrangements, and support; money, how to handle bills, debts, and savings; property, who keeps the home, car, furniture, or family photos; and other matters, things like name changes or safety orders. This list makes sure you share everything important to you. Gather anything like records or documents that you think will help the mediator communicate what you want. Both parties may be together or in separate rooms when the mediator introduces themselves and gives a short explanation of how the process works. The mediator will talk about their rules, like being respectful to everyone and not speaking over each other, and what to expect from the mediation. The mediator may have everyone stay in the same room and ask one party to speak first, then ask another party to speak, and so on. The mediator may make suggestions or ask questions as each party speaks, or they may wait until the end, until each party has spoken to give advice and ask questions. They will try to help everyone come to an agreement to settle the case. The mediator may also have each party go into a different, separate room after the introduction. If this happens, the mediator will speak to you and the other party or parties separately. The mediator will go back and forth between the rooms to help everyone come to an agreement. If mediation is on Zoom or another virtual platform, each party will probably have their own separate breakout room with the mediator. However the mediator chooses to run things, they will likely meet privately with each party near the end of mediation to discuss the likely outcomes and make any final suggestions if an agreement has not been reached. When mediation is finished, one of two things will happen. If both parties cannot agree to a compromise or settlement, the mediator will write a report to the judge to let them know mediation ended in an impasse. The court will continue from here on to a different form of alternative dispute resolution or litigation. If both parties agree to a compromise or settlement, the mediator will write up an agreement for all parties to sign. The mediator will then write a report to the judge to let them know what the terms of the compromise or settlement are, so the judge can enforce it and close part or all of the case. The mediated settlement agreement is binding, meaning the parties cannot back out of the agreement. It is important to be sure that you agree with all parts of the settlement before you sign the agreement. Mediation works best when both people have equal power and can speak freely. Mediation might not work well if you feel scared or forced. If you feel unsafe, you can ask the mediators for extra safety measures, such as no direct contact between the parties and separate arrival times to an in-person mediation. If this is a case involving family violence, you or your attorney can file an objection to the mediation called a motion to waive mediation. This will allow you the opportunity to explain to the judge why it is not good for you to be around the other party or parties. If the court agrees with your reason, they will try to find steps to take to keep you safe. Mediation encourages resolving problems and making compromises. But remember, your safety and well-being are the most important things. If you ever feel unsafe, there are ways to ask for extra help and protection. If you ever have questions or need more information, don't hesitate to reach out to a trusted adult, lawyer, or advocate. If you are in need of legal advice or have any questions, you can contact the Texas Advocacy Project legal line at 800-374-HOPE to schedule an appointment. That is 800-374-HOPE. Thank you.